want to open the meeting of the Buchanan County Zoning Board. This is a continuation of an application
Is
by...
that on, Dave?
Is it working?
No. Now try it.
This is a continuation of a hearing held approximately 2 weeks ago. And it was postponed because we're missing one of our board members. We have a full board right now, and we're now at the point of taking a vote. The chair will entertain a motion to approve the conditional use permit.
For the record, can we indicate the
conditions.
case number?
I'm sorry?
For the record, can we indicate the case number that we're talking about?
Oh, sure, I'm sorry. The application number is 2022-042.
No. What you're doing right now is 2022-002.
Yeah.
That's it?
002, yeah.
Okay,
What you're referring to is what you're going to talk about later.
right. Okay, so now I'll entertain a motion.
That's next
We
week.
have to do conditions first, Dave. The
Oh, yeah.
conditions are up on the screen.
What are the conditions?
Both sides on the screen.
Okay, I'm going to read out the conditions that's proposed by the staff. Number one, the conditional use permits shall expire 10 years from the date of approvals by the McHenry County Board. Number two, all other federal and state and local laws shall be met. Anyone have any further conditions? Anyone have any further conditions?
I move we approve the conditions.
Second.
Moved by Kustra, seconded by Eldridge, that we accept the conditions as they are. All those in favor, well, let's take since there's only two, we're going to go with voice vote. All those in favor of the conditions 1 and 2, please say aye.
Aye.
Opposed? Motion carried. Now, the chair will entertain a motion to approve the application for conditional use permit.
So moved.
Second.
I think we already had that motion.
No, we didn't.
Question is, discussions at this point. Who made the motion?
Linnea.
Go ahead, Linnea.
Yes, this is an application for a conditional use for a residential care facility. I think this is something that's really needed in the county. It's something new. I think this location is perfect. This is a home that will only have just a few residents, and there will be adequate staff. I believe they've met the conditions for adequate parking. They have addressed all the conditions that within the ordinance for this residential care facility, what they would need to do for that, as well as their approval standards for a conditional use permit. I think this is in an area, it's near the Fox River in an unincorporated area, and I think it's just so innocuous that people won't even know it's there. So I think it's really compatible with what's planned in the area. I'm familiar with other homes like this in other areas, and they just really fit in well with the residential, in a residential area, caring for older people. And so I don't think there's any worries about any detriment, endangering the public health, safety, and morals. I think they've really done their homework on getting their licensing. what they'll need to do for that, and making sure that that everything is provided for. They have addressed the parking issue, they have that done, they've gotten approval from the township for what they want to do as far as the parking. And anyhow, I just think this would just be a lovely addition. I think it's good people that want to do this, and I think it meets the standards in our ordinance, so I'll be voting for this.
Mr. Schnabel.
I have nothing really to add to what Linnea said. I do have some other concerns about the overall business plan, but that's not what we're here really to discuss today. So I think overall I would tend to support approving the petition.
Ms. Gardner.
I agree with everything that Mrs. Kuster said. This is indeed a residential use for this property in a residential neighborhood. So I think that it fits in perfectly. I also think that this is a use that's going to be needed more and more as time goes on and our population ages. I know myself, I had my own mom at her home with in-home care. And there were, at any given time, 2 people, 3 people in that house taking care of her. And nobody in the neighborhood said, we can't have this. This was perfectly normal. This woman, my mother, was living in her own home with care. And that's what we're all gonna need at some point, is more care. This is kind of a nice step in between total assisted living and independent living. This is kind of independent assisted living because they're on their own for almost everything, but there are people there to make sure that they're okay, that they get in and out of the bathtub, that they get out of bed safely, that they eat, that they take their pills. I think this is a wonderful step for aging people. I also think that it's great that it keeps the costs down for these residents who would be in this home. I think that's a real plus for this type of arrangement. It also creates revenue for the county, somewhat, not a whole lot, but something. It's a very quiet use, it's a passive use. We're not gonna see, wild parties in the backyard or anything like that. It is becoming much more common out west. We're not that familiar with it in this part of the country, but I think that as time goes on, we will become much more familiar with this type of residential use. I really feel that this is a good thing, and I am applauding these applicants for coming forward and bravely putting forth their plan to a county that has probably nothing like this yet. So I am in favor.
Mr. Eldridge.
Yes, I want to note for the record that I was not present at the hearing, but I read the transcript. I agree with everything that has been said up to this point. I want to comment that I believe that all the standards have been met for a conditional use. I myself, when I was a younger person, was end-of-life guardian for 7 different relatives and had to provide for or arrange for their care for a number of years in some cases. And my experience of it is that it has very little impact outside the residence itself. Even in one case where we were dealing with someone who was globally demented, who required multiple people there at all times, and in a large apartment building, there was no impact outside the apartment. The building didn't in fact know what was going on, and in spite of 4 years of this, there was simply no discussion of any sort by anybody that one of their neighbors was undergoing this type of care. So I believe that any concern people may have that this is going to be in any way disruptive is misplaced. So I will support the petition.
Mr. Smolinski.
Yes, I very strongly agree with the comments that Mrs. Gardner has put forth. I think that this is a use that's going to be needed more and more in this county. And anytime you can have people live in a house rather than an institutional setting is a huge advantage for the care that's required for the elderly these days. So I believe that the applicant has met the conditional use requirements, and I will support the petition.
Mr. Cozen.
Hello. Thank you, Mr. Chairman. I have no dispute with the necessity for such a use. Apparently, it is also recognized the necessity by our Illinois legislature creating a statutory framework for this. The county, by creating this as a conditional use. But when I examine the location and the provisions that are required of the applicant, I cannot come forward, and I wish to have a moment of time to reflect in terms of the location. This particular location is equidistant from 2 fire stations, not closer to one or the other, but 2 different. It is within 600 feet of the Fox River, of which the inhabitants are ones that have already been described as needing care and protection from the most basic needs of walking out of a building. And when you look at the building itself and the floor plan that was presented, we notice that one of the bedrooms does not have direct access out, but has a 12-foot path to enter a sliding door. Another bedroom has to pass through a mudroom, possibly through a garage with an overhead door. The doors themselves open inward and not outward like each one of us experienced today when we came to this meeting. When the applicant was before us, the applicant has no prior experience. In fact, it needed a signature to qualify for the purchasing of this lot. The applicant, in fact, mentioned several times upon questioning that those were good questions that we were asking, rather than providing good answers. In an economic discussion, one is always sometimes heard to say, would you put your mother's money in this investment opportunity? To turn it around, one could ask, would you put your mother's care in this facility? For that reasons previously stated, I will not be supporting this application.
I tend to agree with the comments that were made up to the time of Mr. Cozen. I agree with him that the drawings we had doesn't make it look like a Holiday Inn, but it probably isn't designed for that. Part of my thinking is that I had a sister-in-law who was in a facility similar to this in Arizona, and that's a very popular way of providing medical help for the elderly in Arizona. So I'm going to vote yes. Mr. Elridge.
Yes.
Ms. Gardner.
Yes.
Ms. Gustra.
Yes.
Mr. Cozen.
No.
Mr. Schnabel.
Yes.
Mr. Smolinski.
Yes.
And Stone is yes. So we'll go to the board with a recommendation of approval 6-1. That concludes this hearing.
Best wishes to you. I know you'll do a fabulous job.
Do you have this next thing? Rayanne Paul Ladowski and John Okay.
You ready?
Ready?
All right.
We better just make sure that there is in the file a public notice that this meeting was published on the Northwest Herald, I believe, on 11/8/2022. Go ahead, Renee.
Okay. So as those of you know who were around in 2014, when the UDO was drafted and passed, it became a UDO because we incorporated the zoning ordinance and the subdivision regulations. So also since 2014, we haven't had a subdivision come through the process. So the subdivision portion of the UDO was never really tested until this year. And earlier this year, we had what should have been a simple re-subdivision of an existing lot into 3 lots. So as we, the Staff Plat Review Committee, which is the committee that processes subdivisions, started looking a little closer, we started seeing a lot of inconsistencies in our application process as it's written in the UDO, and some omissions. So we, after that experience, we decided we probably need to clean up the subdivision application section. So that's what this is. By and large, it is just cleanup. Doesn't really change much. The only thing that it does change is, in the past, the subdivision process had an optional concept plan meeting. So if I'm gonna subdivide my property, I could do just a sketch plan, not spend much money, come before the Staff Plat Review Committee and have a conversation with everybody in one room, with the transportation people, the health people, engineers, everybody. That was optional. So when we rewrote this, we decided to make that mandatory, which is consistent with Lake County and Kane County. As a way, it's just a good way to have a conversation before people start hiring engineers and actually spending money. So we made that change, and then the only other change is previously subdivision ordinances, subdivision plats require certain officials to sign off on them. So there's always certificate language that we prefer that go on the plat for these officials to sign. There's also easement language that we always need on the subdivision plats to take care of the utility easements that have to be platted and that sort of thing. Those were part of the UDO in an appendix. So we're proposing to take that out of the UDO. And the reason is, if we changed our mind about the language of easement or signature certificate, we would have to go through this whole process of text amendment to make that minor change. So I checked with other counties. Kane County, they don't include it in the actual text of the ordinance. They just have it on their website. So when a subdivider comes through, when they get to that point of preparing their preliminary and final plats, they're given that by staff. So we're proposing to operate the same way. So that's about it. It's nothing very exciting. So I will open it up to questions. It has gone to PED. It went to the PED committee in October, and they gave us the green light to take it through the process.
Any questions from the board?
We have this very thoughtful letter from the environmental groups, and basically none of which are really addressed in the changes that are proposed today. It seems to me they ought to be at least thought through. Is your recommendation that that happen now, or that we wait until we are doing this again next year?
Now, I can address the changes as I believe I'm interpreting them, and then if I'm incorrect, I believe there's someone in the audience.
Yeah,
that
there certainly is somebody who
probably
can
will
comment.
be able to correct me. So I talked to Joanna. Joanna and I met this morning and went through the list, since she's the expert in some of these
Yes.
things. So I'll just very briefly give you our conclusions, if
Okay.
you would like. So the first one was contacting the watershed groups. So we feel like what we have, the language that we have in the ordinance is what we would like to stick with, because Joanna's division keeps the list of active watershed groups and active drainage districts as well. So we don't mean to, and we don't want to exclude anybody. Anybody that we know about, we certainly will send a notice to and let them know that something's going on. But we just want to be very careful about the language of the ordinance, because legislatively, we don't want to be beholden to send a notice to some group that we aren't aware of, that we miss because they're not part of our registry, they're not part of the groups that the county board has approved in some way.
So how would someone get on that list?
Well, the watershed groups have watershed plans that are approved by IEPA and the county board. So Joanna has those, and she knows about the groups. And we have some watershed plans that are on file without active groups. I don't know that we have any active groups without approved plans.
The Kishwaukee River.
Lisa, would you just
partnership.
identify
I'm
yourself,
sorry.
please?
That was my fault. I
Why don't
lost
you come
that.
on
I'm
up here
sorry.
to the microphone?
Yeah, and should Lisa be sworn?
Do you want to be sworn in?
Okay, yes.
I solemnly swear that your testimony you give today will be the truth, the whole truth, and nothing but the truth.
I do.
Yes. And my name's Lisa Hatterline, and do I need to turn this on?
Yeah, turn it towards the mic.
Okay. So that,
Yeah.
that works, okay. Yeah, my name is Lisa Hatterline. I'm the Executive Director at the Land Conservancy of McHenry County, and I live at 904 North Jefferson Street in Harvard, Illinois. And to respond to the question about the watershed groups, there is a group, the Kishwaukee River Ecosystem Partnership, which has existed since the 90s. It's an old state program. And they are a watershed group. They sort of volunteer-led, and they're a good group, but there isn't a Kishwaukee River plan that's approved by the EPA. There's I think it's the not North Branch. There's one of the branches of the Kishwaukee River that's by Huntley and Woodstock, and then the Lawrence Creek are the two sort of sub-watersheds of the Kishwaukee that have plans that are formally approved, and they both do get notice.
So what would be the difference then, if you don't mind me then asking, Mr. Chairman, if I can just ask Lisa directly then about.
You have my absolute
Okay.
permission.
Thank you. Okay, so this group that's been in existence for, 30 years maybe, but they don't have EPA, IEPA, I mean, is there an obstacle to them getting that? Or do these other groups that are like North Branch or whatever, do they suffice and they take care of it? So,
Well, part of it is when the two plans were done, and there were actually at some point, and this is, stretching my memory, but it's going back probably 12 years to when the partnership had enough funding to be able to work with the Illinois EPA and the CMAP, Chicago Metropolitan Agency for Planning, to do 3 sub-watershed plans, because the whole Kishwaukee is huge. It's a very large watershed that goes into 3 counties and actually into Wisconsin. But so they didn't have enough resources to do the whole watershed, so they did 3 sub-watersheds, one that's in Boone and Winnebago, and then 2 in McHenry County. So that was how they came to do 3 Illinois EPA, what are called 319 watershed plans. So it's a question of cost and time, and it was just felt that was at the time that was the best approach. So it's not that it wouldn't be eligible to do one of those plans, but it just hasn't been done. So, but personally, I am happy to hear the explanation on this myself, and how this is cleaning things up and not changing. It's not taking things away, but actually keeping it the same. And it looks like adding the drainage districts for notice.
Okay.
Yeah. And that seemed and I can't speak for everybody, because we didn't actually have a meeting. It was all via email, but the concern was that making sure that it's it's watershed groups and drainage districts, not slash, because they're very different. They're very different kinds of entities. But does that help?
So what are we approving? I have a document I took out of the file called Chapter 16.24 Subdivision Applications. Is that what we're approving?
No.
What is
Yeah.
it that we're?
This is
Basically,
the-
the whole thing,
yeah,
Yeah,
we're
that is,
updating
that's part
that.
of it, we're updating
We're
that.
updating that data.
Well, don't you think we should have something in the file that marks what we're doing?
It is. You got red and green, what we're changing. The
When do we do
language is
that?
in there.
They didn't, yes.
They did that today?
No.
No, staff presented this as
Yeah,
the changes are recommended. This is what they're presenting to us.
Yeah, it's just a red line copy of that chapter of the UDO.
So if we vote this up, we're voting this document up.
yes.
Okay, I'm gonna put the date. What is today's date?
December 1.
December 1.
Yes.
My initials and adopted.
Oh, we got
Lisa,
more people to hear
at this
from.
point, based on that explanation, is there anything else that you feel needs to be in this that isn't?
Well, I would echo one of the questions in there about the Crystal Lake and the water, the proximity to the different water bodies, and also ask about the Kishwaukee River reference to that. since the fox is in there, and I don't know if that's something that's a legislative thing at the state level, that it's reflecting that. That would be my main question.
Okay. That is in section, well, in your packet, it looks like you'll find it on page 57. And it's in accordance with an act in relation to the regulation of rivers, lakes, streams of Illinois. And then it actually lists
It
waterways.
goes 28 to, we only have 28 pages, so we have to go to the section of the ordinance, so it's 16.24.
Yeah. So it is.
.060. So I'm thinking it's on page 15 of 28.
I know it was
If
meant
that
to
looks
be.
like
List
submittal
of-
requirements.
It's under final plat. It's under final plat requirement.
Okay, that's page
And it's a-
18 of 28.
Thank you. Yep.
This is a mess, you know, my copy that I admitted into evidence has questions written on it.
What you have here is a staff draft.
Uh-oh. Here, use mine, Dave. We'll share
You want to
mine.
get me the document we're approving?
Here, this is mine. This is what we're talking about now. We'll just share it. And then you can use mine for your approval.
Okay, so there's a list of waterways there that we've modified, that we've changed. And the reason for that is we aren't sure where this list came from because the
Is that on,
intent.
that would be on page 22 of 28 where you list those, I believe?
Yes, that's correct.
Yeah.
Okay.
So we're not sure where this list came from in the original, in the ordinance, because what the section is referring to is the list of waterways that are regulated by the DNR. And it's just basically mimicking the state requirements and of what we have to do to notify and get approval from DNR and on those waterways. So we changed the waterways to reflect what's in what DNR controls and what's in the stormwater management ordinance as well. So that was one of those inconsistencies that we found.
So you're trying to mirror other documents, basically?
The list as it existed was incorrect because, for example, DNR doesn't regulate the Nippersink. So we just refined the list, changed the list to correct it.
This procedure seems a little leaky to me.
I'll let you work on that.
He's been waiting for that.
He has. And then I think the next question was about the plat of technical adjustment. So those plats of technical adjustment, that's something that's very granular. It's very site specific. And the kinds of things, we've done a few of those this year, and the kinds of things that we do is when a subdivision is platted and there are hydric soils or there's floodplain on the property, then the area for septic suitability is always identified on each of the lots. But then when someone starts to build and really digs into it, starts doing soil borings and those sorts of things, often they need to adjust those areas of soil suitability for septic. So that's all those are. So they're so technical and granular that they don't have an impact on the overall watershed in any way.
Got you. Thank you very much.
Sure.
Do you have any further issues with this that we should address?
No, not specifically. Are there any other questions
Is this
while
on
I'm
the date
here?
line?
I know somebody else has.
I believe Mr. Cozen might have a.
It's our agenda for today.
Go ahead,
That's what's
Bob.
on the agenda. So
Go
this is the text amendment that's on the agenda.
I'll stand on ceremony.
We have some other person in the public.
But I
that's
think
gonna
Bob
comment.
has a- Bob
Bob
has a
wants to ask a question.
Cozen wants to ask a question. We're not ready to vote yet.
Go ahead, Bob.
Thank you, sir.
Would it be then helpful to have a definition of active drainage district? Because it seems it's a term of art specific to McHenry County.
Well, an active drainage district in our mind is one that's been approved by the court system.
Right, but
So,
not to be too flippant,
yeah.
but the applicant isn't a mind reader. Would he not be benefit from where that active drainage district means? Is there a directory, something that leads them to that active may mean that they have a Christmas party? Active may mean that they meet on an annual basis. Should not a definition be applied? Because and that's what we're spending a lot of this time on, is the distinction between watershed groups, groups that file WBPs, drainage districts, and then.
Well,
Yeah.
and
It's a
excuse
good
me,
point.
one more point.
Yeah.
We spent a substantial amount of time, and I learned a lot about Coon Creek, and the history of Coon Creek.
We all did.
And how it emerged and so forth. And so where would a place like Coon Creek fit in the notice requirement in terms of an act? So that's my point. I'm sorry, a long way around the barn, as they would say, but would not
Because they're a
benefit-
drainage district, they would be notified.
Right, but there's a definition of who qualifies under statute as a drainage district. Would not we benefit from what is known as an active drainage district? Because that's the qualifier that staff is putting forward, and what's an active?
Well, I think we just assumed active means active. They have a board,
Wouldn't
so we can do that. Well, the
Yeah, so that
qualifier
one's
that we
right,
put
so
in
this
was
might-
that they have a plan accepted by the county board.
Right, and that was one of my,
So time will tell.
now we have a list of plans that have been
We
accepted.
do, yeah, we have
Right.
those. Those are all
Right.
online. Yeah. So I guess in our minds, our qualifier is that they have an adopted plan by the county board.
I don't know that we need to know much more than that. If they're a registered group, then that's all we can do. We can't make them have meetings, right?
And then our stormwater division has certain responsibilities with the drainage districts, for sure. I don't know about the stormwater, but, about the watershed districts, but the drainage districts, they certainly know who's active and who isn't active, so.
And we've got a member of the public who wants to talk.
Okay. Sir, please state your name and address.
Sure.
You can take that microphone out if you'd like, and hold it.
I don't think I'll need to hold it. Can everybody hear me? My name is Jan Vanderspool. I live at 8708 Bull Run Trail. I'm in a subdivision known as Bull Run Estates. Wanted to speak to you about the proposed text amendments. One thing that I would suggest not be removed is a reference to homeowners associations. I believe that applies in 3 places in the planning process. Since this ordinance involves subdividing and re-subdividing, and with my belief that the county UDO gives all interested people the opportunity to have a voice in what happens. There's a phrase that says homeowners associations that have expressed an interest shall get whatever is involved in the 3 places that phrase appears. In terms of streamlining it, I think deleting those phrases suppresses the voice of those that ought to have an opportunity to speak, especially with re-subdividing. And so my request and proposal is that you do not delete that. Because it says homeowners associations that have expressed an interest, I do not see it as a direct roadblock to expeditious completion of the process. because it's not a phrase that says you gotta notify all homeowners associations, you gotta send out notices. Nothing like that is involved in the phrasing. It just says those that have expressed an interest. And so if they are adjacent or part of it or whatever's going on and have expressed an interest, they ought to continue to have an opportunity to have an input to the subdivision or re-subdivision.
That
Thank you.
sounds like a pretty loose phrase to be using that, in my mind.
Yeah, Renee,
Oh,
do you
well.
have a
Well, that's
response?
exactly why we were proposing taking it out, because what does it really mean?
Okay.
So that's why we took it out. And I think one thing that we have to remember when we're talking about the subdivision ordinance is it's much different than zoning. Zoning, there's no public hearing with a subdivision ordinance. A subdivision is a very technical thing. So you have your public hearing for zoning, so that's where everyone comes in and says, yes, we want a subdivision, we don't want a subdivision, we want this density or that density. All that's been done, and that part is over.
And
So
are you saying
not
that
to
that's the place where the homeowners association could come in? and-
Correct,
Yeah.
that's where they would come in and state their concerns, and all that would be alleviated. The subdivision itself is, it's very technical. The process is run by the Staff Plat Review Committee. It is ultimately approved by the county board, but I know in the past, there was an issue where they tried to deny a subdivision that the state's attorney gave them this talk, that this is a technical thing, it's not, you've already talked about the appropriateness of density and those sorts of things. So, just keep
Yeah,
that in mind.
and the public is, certainly at the zoning part of it, the public is,
Well, so did we address this
Has the
gentleman's
opportunity.
concern or not?
Correct.
So this change is actually protecting the county from, any charge, so that they make sure that they are following the technical aspects of this in the staff plat review, and not
Correct.
trying to go beyond that,
Correct.
and allowing the homeowners association to come in through the zoning hearing, which they've already had the opportunity to do.
The right to do, correct.
Okay.
So my only concern with these is that we've said we have to notify these people. This is our law, this is what we have to do. And somebody gets all the way through the subdivision process, and then there's a legal challenge because somebody didn't get some notification. We don't want to exclude anybody. So anybody that we know about that's interested, we'll let them know. And the staff plat meetings are public meetings. Anybody can attend and can speak, but they're different than public hearings for zoning.
Yes, ma'am.
Could I ask a question about that? Yeah, sorry. So if there's, let's say, a part of an existing subdivision that is being re-subdivided, because, let's say, somebody owns a bunch of lots and decides they want to reconfigure them, or somebody's gotten the restriction taken off of an outlot that they purchased, which I've seen this happen, and is now going to turn that into 3 lots. There's no mechanism for notifying the homeowners association that that change is happening. That seems to me because the zoning's in place, but if it's just a technical process, then
No, a
they're not getting
re-subdivision.
any notice.
a re-subdivision is a zoning change.
No, it wouldn't require technically, but practically, if there's already a subdivision,
Right.
then there's already covenants and restrictions, because we require that as part of the subdivision process. So those covenants and restrictions would certainly require that everybody be notified if there was gonna be a further subdividing of the property.
But that's not, I mean, the covenants and restrictions are private.
Correct.
I mean, those aren't, so who's gonna do that notification? It seems like it would be up to the HOA to do the notification, but if they're not gonna know that the re-subdivision is happening.
Whoever's re-subdividing would be legally responsible to notify the neighbors.
Okay.
That's always the case, that they have to notify the neighbors.
I'm sorry.
You
I
look a
didn't
little
see that.
skeptical.
Okay.
I
I'm
didn't see
just-
that phrasing in UDO, that they have to notify neighbors about anything. So I would disagree.
Board want to make a motion to exclude that?
Would that be part, Renee, if it's a subdivision? I mean, because for a zoning petition, they have to notify all the neighbors. So if they're gonna re-subdivide, they'd also have to re-notify all the neighbors?
They don't.
Oh, they don't?
They don't, is in the UDO, in the subdivision regs, doesn't require it. But their covenants and restrictions would certainly require it.
Well, I'm not in a subdivision, obviously, so I don't know about all that stuff, but I mean, it's a legitimate concern.
Yeah, but if they fail to do it, that's a cause of action on the part of the HOA against the people who were re-subdividing.
So it's out of our hands, is what you're saying?
Yeah, so it's between the subdivider and the HOA. Without the, if the county is obligated to make these notices, the county has liability.
I hope they have a better time in court understanding this stuff.
Nobody has a good time in court.
I did. Sometimes.
Well, you were on the getting paid end of that.
So Charlie, you're basically saying this, you know, by what we're doing, we're just removing the county from any liability, and
I think
the
so.
two of them,
Yeah,
those two organizations then
Yeah.
have to do that. Okay.
So did you make the amendments to that we needed?
Based on what I'm hearing, what is proposed by staff is what we would recommend. You know, that is what staff is recommending, is that language be removed, that we would not be notifying homeowners associations. What you said is kind of loosey language, that you didn't like it. That's what staff also thought, and so they removed it.
Okay, where are we at now?
I would agree with Ms. Hatterline in taking that slash out between watershed districts and drainage districts and replacing that with an and. So I would make that change.
I will move that change be made.
Second.
But we do have
Any further discussion? If not,
Can you show us the page on that, or the
That would be
section?
page
so we-
5 of 28.
That's on page 28, or that?
5 of
5
28.
of 28.
5 of 28. Under letter M.
Yep. And it appears elsewhere. But today's technology, just say.
is this going to bring Colson on board?
It's also on page 6 of 28.
Mr. Cozen has a comment.
One more, Mr. Chairman. Just on that same page, there is an addition, which is the blue underline, as I take it, refers to nearest municipal planning commissions. And then the letter we received referenced the deletion of approval by, could you just reconcile?
Sure, that's all set out in state statute. So the preliminary plan has to be, the preliminary subdivision plat has to be signed by the plan commission for some reason, but then the final plat has to be signed by the highest elected official. So the mayor or the village board president. And that's within 1.5 mile jurisdiction.
Or where there's a boundary agreement or shared.
Correct.
And then what about townships that have adopted planning? Is there any in the county?
There isn't, they don't have to sign, of course, the township road commissioner has to sign both the preliminary and the final plan.
Mr. Chairman, that concludes Mr. Cozen's comment.
So Charlie, I have a question for you. So it's in here multiple times. So would you be comfortable with your amendment being that any time
Yes,
language is watershed groups
Yes.
/ active drainage districts, we insert and?
Yes.
Okay, and I'm seconding that too. Okay.
Okay, let's,
So we're gonna vote on that
vote on that
amendment?
change.
this is it, right, the whole
We
thing?
gotta vote on the amendment first,
Where's that?
that Charlie and I just proposed. This language, wherever it's in the ordinance, is gonna be changed to and.
Is somebody gonna go through this document?
No,
We just
we
did.
just
Yeah.
just
That does
proposed
it?
this change, that's it. We can just vote on it as is.
Okay, Chair will entertain a motion to approve.
I made the motion.
Charlie made the
It's
motion,
been-
and I seconded.
Yes, and it's
Yeah.
been amended already.
Been moved and seconded by, moved by Charlie, seconded by Linnea.
To insert and
To insert the word "and"
wherever this is listed.
Yeah, and delete the slash.
And delete the slash.
and delete the slash. That's it?
Yep.
That's the big.
Okay. Do we really need any discussion on this?
We did already.
Does anyone understand?
Yep.
Yes.
Okay. All right. I'm gonna call, does this require
I think a voice vote. is
Voice
appropriate.
vote.
Okay, all in favor of the amendment signify by saying aye.
Aye.
Opposed, nay.
Yeah, and
Motion carried.
I make a motion that we adopt the changes as amended.
Second.
And under, as amended, under exhibit,
I'm going to call this exhibit number 1, exhibit A.
okay, exhibit A is admitted as of 12/1/22. Put back in the file, hopefully never to be seen again.
We need discussion.
We have to do what?
We need Charlie to have discussion
Yeah.
on the motion.
Charlie, discussion on this motion?
Yes, I believe that the county PED has put forth to us some proposed changes recommended by staff that are of a technical nature, which are just cleaning up some language that wasn't addressed when the UDO was originally adopted. I believe these are improvements to the UDO, and I support the request.
Mr. Schnabel?
I fully agree and will support the request as well.
Ms. Gardner?
I have nothing further to add, and I agree.
Ms. Kustra?
Yes, I agree with Mr. Eldridge. I think this does what staff is hoping to do to make this so that we protect the county better. We simplify the language, we make it better so we meet legal standards for the state. I'm in favor.
Mr. Smolsky?
I agree with Mr. Eldridge's comments on this and will support the application.
Mr. Cozen, we're all waiting.
Succinctly, Mr. Chairman, I too support this.
All right. That makes us all feel good. Okay. Motion has been, I guess we have to do the actual vote. Eldridge?
Yes.
Kustra?
Yes?
Gardner?
Yes.
Cozen?
Yes.
Schnabel?
Yes.
Smolinski?
Yes.
Stone, yes. Goes to the county board, 7-0 recommendation.
Another great victory for the zoning board.
Hey, everybody. Hey, everybody. Remember, next week is our Christmas party. I didn't hear from everybody.
I didn't get it.
You didn't get the email?
Again.
Every
year.
Okay, so, Don, are you coming?
Yes.
Okay, Charlie?
I'll be there.
Okay, you'll be there. It's at Three Brothers.